is Senate File 14. Reading clerk, please read the bill.
Senate File 14, sponsored by Transportation. Wyoming National Guard Professional Malpractice Liability, an act relating to Wyoming National Guard. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom is referred Senate File 14, Wyoming National Guard Professional Malpractice Liability. Respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Wiley. Noes, Representative Stivar. Representative O'Hearn, Vice Chairman.
You've heard the reading of the bill. Mr. Chairman, what is your pleasure?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 14 do pass, and I turn it over to the freshman legislator from the northern part of the state.
Representative Pendergraft.
Thank you, Mr. Chairman. Ladies and gentlemen of the 67th, I bring you Senate File 14, and I ask for your favorable consideration. It's a very simple bill. A little bit of background, if we would look at the statutes in 199401, it says any member of the Wyoming National Guard who possesses a license or credentials to practice a trade or profession in another jurisdiction, or who meets the requirements of the Wyoming National Guard for the practice of any professional, mechanical, teaching, training, or other skill, may perform that practice, skill, trade, or profession without first being licensed or otherwise possessing credentials under any Wyoming licensure laws during those times that he's serving in the Wyoming National Guard active service status. Okay, that's existing statute. So what this bill does is take the very next piece, 199402, and make them work together. As it exists, 199402 extends indemnity to attorneys or doctors of medicine. We've struck that, and we've expanded that to say anyone who possesses a license or credentials to practice a profession, and who meets the requirements of the Wyoming National Guard for the practice of the profession. As you can see, it's pretty simple, straightforward deal. I would certainly entertain any questions, and if there are none, I call for the question.
Question having been called, not seeing any others. Representative Jennings.
Yeah, could we get, Mr. Chairman, could we get a little more explanation on the malpractice part of that? What does that look like?
Representative Pendergraft.
Representative Jennings. Mr. Chairman, Representative Jennings. I don't know. I would defer to the good chairman of transportation.
Chairman Brown.
Thank you, Mr. Chairman. So the understanding behind this bill, as the good bringer was explaining to you, the malpractice behind this is whether or not somebody is acting in their official capacity as a Guard member in their line and in their profession, they would be exempt from any type of malpractice suit. And so that's what we're trying to accomplish here is to cover them. This was originally built in the line. I'm trying to remember exactly who it was for, but there was originally it was medicine or doctor. And so this is now encompassing anybody that would be in there, specifically, like, let's think if an engineer was acting in their behalf, or in their capacity as an engineer in the Guard, and something occurred with a bridge, they would not be held personally or liably responsible for their damages, and you couldn't sue them in their official capacity because they're working on behalf of the government at that point as a Guard member.
Representative O'Hearn.
Thank you, Mr. Chairman. Yeah, this has been an interim topic. It used to just cover doctors and lawyers. If a veterinarian that is also on status as a guardsman and someone runs over a dog and he can go out and fix it, he does that. So it covers all the other people that have professional licenses in the state of Wyoming when they're acting as a guardsman in the uniform on duty. Interim topic. Go for the bill.
Representative Jennings.
Thank you, Mr. Chairman. So are we rolling them into like the government immunity, the state government thing that like we did a few years back where we made clinics an employee so that we could cover them with the Governmental Immunity Act? Are we doing that through that? And how far reaching is that? I'm hearing doctors, I'm hearing veterinarians. What else might? I mean, and how does that work outside of the Guard? I mean, there are people that do their private practice and they cover their own insurance, or they set up things in another, away from one line of work. So how far does this reach?
Chairman Brown?
Thank you, Mr. Chairman. So, good question. And if you look at the bill says any National Guard member who possesses a license or credentials to practice a profession in the state and who meets the criteria and the requirements of a Wyoming National Guard for the practice of their profession. And if you look right above it on page 1, line 13, the state shall defend, hold harmless, and indemnify any of those members. So to the question that we rolled this back a few years ago, it's similar in nature, but you're only talking about a Guard member who's on Guard status, who is acting as a Guardsman in their professional role. Are they held harmless, and shall they be defended by the state at this point in time? So this is not something that we're going out and crossing the bridges, but this is something that would be in the case of, as the good representative just brought, from a veterinarian, for instance. Anybody else who holds those types of professional licenses or any type of a credential that is held by the state, they would be the ones that would be held harmless.
Representative Wiley?
Thank you, Mr. Chairman. I think just to kind of simplify this down to layman's terms, it's for when the executive says, hey, the barn's on fire and we need the Guard to come up and put it out. We want people to show up and put it out because they're not afraid that if it falls down on the house next door, that they're going to be liable. So just simply put, we're protecting the folks that we need when times are bad and we need them to show up. This is what it does. Thank you.
Representative Jennings?
One more, then I'll quit taking a bite. I noticed there's no fiscal note on this. In committee, was there any talk about how many people this is going to capture? How many people is the state going to be on the hook for? How much insurance? I mean, how many people are we talking about?
Chairman Brown?
Thank you, Mr. Chairman. No, there was no discussion on that. And the reason there's no fiscal note is because there's no fiscal impact. And I think the understanding of, and I've been kind of maybe misunderstanding the questions that were brought up. There is still the potential that you could raise suit. But the interesting thing about it is that the state is going to defend, and they cannot be sued by their person. Okay, they cannot be sued in their person. So, but no, there was no discussion in regards to the amount of members that this covers. This is an interim topic that was brought forward. I apologize that I don't have the exact numbers, but I can certainly bring those back for you if you're interested on second reading or third reading and get you all the information.
Seeing no one else, sensing the question. Question having been called. All those in favor of Chairman Brown's motion that when the committee of the whole rise to report, to do so with the recommendation that Senate File 14 do pass. All those in favor say aye. Aye. Those opposed, no. The ayes have it. That is passed. Senate File 14 is passed the committee of the whole. The next bill for our consideration is Senate File 15. The reading clerk, would you please read the bill?
Senate File 15, sponsored by Transportation. Military leave for state employees. An act relating to Defense Forces and Affairs. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred Senate File 15, military leave for state employees, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Stivar, Wiley. Representative O'Hearn, Vice Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Brown?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 15 do pass. And I'll further turn over the explanation to their good freshman representative from where the water is sweet.
Representative Nemec.
Ladies and gentlemen, I bring you Senate File 15. It's a pretty complicated bill if you look at it. It's pro guard and reserve. And if you go on to page 2, it just strikes language, who has been employed for 1 year. Right now, municipal, county, and state entities, when they hire a National Guard member, they're already doing it. They're already kind of waiving that 1 year. So we're just trying to strike that language. So support your guard, support your reserve. Please vote aye. Stand for questions.
Question having been called. All those in favor of Chairman Brown's motion that when the Committee of the Whole rise to report it, do so with the recommendation that Senate File 15 do pass. All those in favor say aye. Aye. Opposed? No. Senate File 15 has passed the Committee of the Whole. The next bill for our consideration is Senate File 17. The reading clerk, would you please read the bill?
Senate File 17, sponsored by Transportation, off-road recreational vehicles, safety and insurance, an act relating to motor vehicles. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred Senate File 17 engrossed, off-road recreational vehicles, safety and insurance, respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Stibar, Wiley. Representative O'Hearn, Vice Chairman.
You've heard the reading of the bill. Chairman Brown, what is your pleasure?
Thank you, Mr. Chairman. I think this is the last time you'll hear from me today. I move that when the Committee of the Whole rises to report, it do so with recommendation that Senate File 17 do pass. And I further move the explanation over to the good freshman representative from the western side of the state.
Representative Berger.
Thank you, Mr. Chairman. So in this bill, Senate File 17, so what we're talking about, in order for an ORV, an off-road vehicle with a trails permit, and that's that little sticker you put on your off-road vehicle, in order for that permit so you can drive on highways or state highways, public right-of-ways, streets, roads, and enrolled or engrossed roads that have been, or roads that have been engrossed, it must have the the vehicle must have the operate safety equipment of a horn, muffler, mirrors, and a braking device, and also you have to have liability insurance on it to be able to access these roads. So I'll stand for any questions.
Any question? Question having been called. All those in favor of Chair? Nope. Okay. Representative Clausen.
Thank you, Chairman. I just want to share a question that I've been receiving from a few people. So for a little clarification, this bill will indeed apply to federal lands and Forest Service roads as well. Can we please clarify this, as this will be a problem to most Wyoming users who are not on paved and state roads? Thank you.
Representative Berger.
Great question. I had that same question in committee, and no. So if it's only the roads and trails that have been engrossed in the state parks. So if you're in the Forest Service, you just have the little sticker. You don't have to have all that requirement stuff. You could still go out in those high mountain trails and Forest Service trails. Make sense?
Representative Hornock.
Thank you, Mr. Chairman. Question on this is, do insurance companies offer this insurance easily? I'm curious what the cost is. So, you know, if it's not something that insurance companies necessarily a service insurance companies necessarily allow. Just curious if that is happening at the moment.
Great question. So yes. Oh, excuse me.
Address the chair,
Oops.
please. Representative Berger? Representative Berger?
Thank you, Mr. Chairman. Excuse me. That's a great question. So yes, a lot of these owners of those side-by-side, especially ones that are going to use these trails, are they're probably worth about $100,000. They insure them themselves. But for those of us who probably like me and use it more recreational, there's insurance policies you can access off your homeowner's insurance, and you can find these policies by all the insurance companies. And then the liability insurance, they put it at a minimum of $25,000. The liability that you have to have at least a minimum of $25,000 dollars worth of liability insurance on these vehicles if you're going to use them for those engrossed trails.
Representative Wiley?
Thank you, Mr. Chairman. Yeah, I would just like to let everybody know that this has been worked pretty heavily, and it has the support of the different departments and insurance agencies, communities within sections of our portion of the state. This is a good bill, and people have put a lot of work into it, and it's got a lot of want and need. And we also need to understand that this is going to be an economic driver for the state itself, because people are going to come in, they're going to purchase these tags, they're going to enjoy our outdoors, and then they're going to get to go home. So just keep that in mind. Thank you.
Representative Hornock?
Thank you, Mr. Chairman. One more question related to that. I can understand insurance for motorcycles because there could be damage to other vehicles. I can understand insurance for cars, things like that. But we're talking about essentially a four-wheeler. It's as defined, it's something less than 50 inches wide, so pretty narrow, little four-wheeler. What is the purpose of insurance? What are we trying to protect? Are we protecting the trees or a fence? What are we trying to make sure gets protected with mandating insurance for these vehicles? Thanks.
Chairman Brown?
Thank you, Mr. Chairman. So the biggest thing about this is you're talking about the roads that are county roads that have been enrolled into the state parks program. And these are county roads, these could be state roads, these are roads that are outside the general jurisdiction of what the state parks would normally be on. So you're gonna be riding next to cars, you're gonna be riding next to other people on a regular basis. And just because it's a four-wheeler doesn't mean it can't cost more than $25,000 worth of damage when something happens. So this is the minimum set of insurance, but it is very likely, especially on a lot of these side-by-side units, that they're going to be carrying far more than $25,000 worth of liability insurance already. And so this is just setting that minimum of $25,000 if they are going to be utilized on these roadways, and they're planning on doing this. And really where this mainly hits is in the southwestern part of the state, where we have a lot of smaller communities that have designated a lot of their main roads in their communities as these state park trails. So they're going to be going through town on paved roads and dirt roads. And so there's this understanding that if you're going to be working and driving back and forth and you're liable and you cause an accident, you need to make sure that you can cover those damages up to a minimum of $25,000.
Representative Hornock?
Thank you. That does make, that clarifies things. Thank you. Will this limit the ability of a rancher who's trying to move cows down one of these roads, who hops on his four-wheeler to go get something that crossed a fence line that's broke a hole through the fence, something like that? So are we going to constrict those type of people because, well, they just happen to jump on their four-wheeler, go move cows or something? Thanks.
Representative Berger?
Thank you, Mr. Chairman. And yes, if we refer to the bill, in the end, there is an ag exemption for that, so that those farmers, ranchers, they're exempt from having all that. So we always put that ag exemption, but it's in the back of the bill there, very last part.
Questioning having been called, all those in favor of Chairman Brown's motion that when the committee of the whole rises to report, to do so with the recommendation that Senate File 17 do pass. All those in favor say aye. Aye. Opposed, say no. The ayes have it. Senate File 17 has passed the committee of the whole. The next bill for your consideration is Senate File 24. Reading clerk, would you please read the bill?
Senate File 24, sponsored by Judiciary. Financial exploitation of vulnerable adults, an act relating to banks, banking, and finance. Mr. Speaker, your committee number 1, Judiciary, to whom was referred Senate File 24, financial exploitation of vulnerable adults, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Nemec, Oakley, Provenza, Rodriguez-Williams, Washit. Noes, Representatives Harrelson and Jennings. Representative Washit, Chairman.
You've heard the reading of the bill. Chairman Washit, what's your pleasure?
Mr. Chairman, I move that when the committee of the whole rises to report, to do so with the recommendation the House Bill Senate File 120 or Senate File 24 do pass. And I turn over explanation of the bill to the House Prosecutor.
Representative Oakley.
Yeah, great. Thank you, Mr. Chairman. So, members, I bring to you House Bill Senate File 24, and do ask for your favorable consideration. So, well, I'll tell you generally what the bill does, and we'll walk through it quickly. So, this bill is in regards to the financial exploitation of vulnerable adults, which is something that is being reported that we're seeing more of around the country. It occurs in a variety of ways, anywhere from caretakers, which is something that I have personally seen, family members, then you can think of targeted scams. So there's kind of a variety there. And specifically what this bill sets out to do is to set a procedure and rules that, if appropriate, would allow banks to put a temporary hold on transactions. One of the things that we discussed and debated, we limited that to 5 days, the time period, under which they can investigate and report to adult protection services, and if warranted, to law enforcement. So that's what we're looking at. So if you go to page 4, obviously vulnerable adult is used a lot in this. That is already defined in statute under the Adult Protection Services in Title 35, so we use that. So then getting to the meat of the bill, it starts out Section A. So if the qualified person in a bank notices this, they have cause to believe, this says they shall notify the financial institution. Then B goes to, then upon that notification, they can assess and create a report, again, if warranted, and then submit that report on the earlier of 2 dates, which is the date that the report is finished, or again, as I mentioned, 5 days after the date of when the financial institution was notified of the potential fraudulent activity. So, and then D, going to page 6, is authorizing and, well, commanding financial institutions to adopt the internal policies and programs and rules for this, which includes, again, specifying who the qualified people are to look at this, how to conduct the assessment, and then authorizing the bank to report that out to the department or to law enforcement. So then the next section, going to the bottom of page 6, top of page 7, is allowing the bank to notify a third person associated with a vulnerable adult, if appropriate, again, as long as, let's say, they're not the suspect, of course, like, again, think of the scams or something. So that could be appropriate to bring in family members. So then in the middle of page 7 discusses that hold that we talked about. So after the report and upon the belief that indeed it is financial exploitation that's happening, a hold can be requested by the department or law enforcement agency. So that goes over that on pages 7 and 8. Page 9 discusses immunity, because of course there is an immunity created for the people reporting, because one of the reasons that it's prohibited currently, you would think, well, maybe a bank should be doing this already, but needless to say, with our financial institutions, we have confidentiality and we have control of our own accounts. So this expressly holds them immune from civil liability in regards to reporting it out and working on it. And then you'll see in page 11, allows the department, in this case, as I've said, I can say it, it's in this, the Department of Family Services, which is what that Adult Protection Services is under, can promulgate rules necessary to implement. So that's the bill. I just want to talk a little bit about the bill. So this type of legislation has been looked at and implemented. It's currently in 34 states. So when you do that, there's a benefit, of course. So we're looking at legislation that has been in practice. They've tweaked it, so our model legislation is based off of things that are currently working, and implemented the effective policy for banks and helping people. This at a federal level, but estimates about Wyoming, their estimates that Wyomingites were probably the victims of fraud to the tune of about $7.8 million in 2021. So of course, that's a significant chunk of change when you're looking at individuals here. For example, in committee, we had a woman come in front of us, and she had signed a power of attorney to her daughter when she was, I think it was having surgery, but and then her daughter took a lot of unauthorized assets. And her testimony, and it makes sense, she's, with something like this, if it would have been in place, the bank, her and her husband's transactions are very normal, routine on what they spend, what their bills are. So, they very well, if somebody was watching, could have flagged all of a sudden these very different large amounts being taken out. And so, and having personal stories does help, right? Because it highlights the situation. Because people talk about, prosecution or making them whole, but the reality is a lot of times this money's gone. When this happens, and if somebody spent it, you can do civil remedies, but if they don't have the money, you're not getting it back. So this gives us an opportunity to prevent it, and it's something that I think we're being asked for, and that solves a problem. And then so finally, and I think this is really key, that gives some security. It would only put a hold on the flagged transactions, on what's happening, not a hold on the account. So, if their utilities are being paid or coming out or something like that, it's not just the whole account is frozen or something. So this would be putting a temporary hold on what at this point, with the policies and procedures, several people would have put their eyes on and said, that's suspect. So this allows that. And again, this is in regards to vulnerable adults. It is something that we see. So it's a tool, and I think it could do some good for some vulnerable people. So with that, I would ask for your aye vote and stand for questions.
Any questions? Majority Floor Leader.
Thank you, Mr. Chairman. To the good bringer, just some curiosity questions. I see the Department of folks that take care of families or service families are the ones that are going to be basically addressing concerns if they come up. What was that discussion like, and what would that look like? For example, let's say a family member, I guess my question would be, how and why will they be taking care of this, or will this be handled within the institution? And why was Department of Family Services brought on? And that just because of the vulnerable adult, potentially there could be abuse or anything like that? Or I'm just curious as to what was the nexus that brought in Department of Family Services in there to kind of handle this? Thank you.
Representative Larson.
Thank you, Mr. Chairman. Protection of vulnerable adults has been in that agency for
been part of that agency's program for a long time.
Yep. Representative Davis. Sorry, I was a lot of heads over there.
Mr. Chairman, I guess who signs this up for the vulnerable? You know, according to the statute there, I just looked it up, vulnerable is 18 and older. So are we just talking about our seniors? Or how do you go through workforce and sign up for this program? Or is this something that the bank will develop and just have an oversight on? Or what's the mechanism for this, how this works? Is that?
Representative Oakley.
Thank you, Mr. Chairman, and I'm getting some help here on the flank, but I've got vulnerable adults is defined, as I said, in Title 35, and that's also what the good representative from my county was talking about, and it is not defined as anybody over 18. The definition is any person over 18 who is unable to manage and take care of himself or his money, assets, or property without assistance as a result of advanced age or physical or mental disability. So again, that's why this is under the Adult Protection Services, under the Department of Family Services, because it is a limited thing and defined, and as again the good representative from my county is kind of an expert on this stuff. This isn't if you're older, we can do this. That doesn't fit the definition.
Representative Bear.
Thank you, Mr. Chairman. I'd just like to follow up on the majority floor leader's question earlier. I do understand that the department that helps families is the one that handles vulnerable adults, but when we're reporting to them, what exactly are we reporting? What kind of action are we expecting that department to take? And my understanding is that we're depending on the institution, the financial institution, to make these decisions as to whether something needs to be looked into or not. Are they qualified to make that decision and then escalate it to where we have the State Department get involved?
Representative Lloyd Larson.
Thank you, Mr. Chairman. I think you can run a parallel line on the way they would handle this with adults is the same way that they have with children. So when there's a complaint comes in to the Department of Family Services on a child, they investigate it and determine if it warrants any legal issues. And then they contact law enforcement in the county or contact county attorney or however, but then it works through the legal process. And as they do in the investigation, then they determine if there's further action required. But it's been established in this agency for quite a while. We have not really funded this effort as well as perhaps I think we should have, or have it to this point. But I think how they administer it is just very similar to how you do it with children, that a complaint comes, or it's identified, they send somebody from the department. We have those agencies in every county and almost every town, that then they would go and investigate and determine, and then they would contact law enforcement, or whoever would then make whatever action they feel is appropriate.
Representative Stivar.
Thank you, Mr. Chairman. Just a question for the bringer of the bill is, how is this going to affect the agency that takes care of guardianship over the people here in Wyoming and their exorbitant fees they're charging them? How is this bill going to affect them, and how's it going to help them? Or will it?
Representative Larson.
When you start getting into some of these, and his point is really a good one, but when you start getting into some of these services
there's cross-jurisdictional stuff. And so what the bringer of the last question points out is if you had, for example, an adult child who is developmentally or intellectually disabled, there might be a guardianship there placed somewhere. And if there is and that guardianship is placed on by that department or is entered into by that department who oversees health, right? No, I'm getting a no here. But there has to be there's got to be some interaction between those agencies. But in this case, if there's a foul in this financial thing, it really comes back through this agency and law enforcement. Now, if it's the guardian who's run afoul, so if you had, for example, an adult child who is receiving services in some place where somebody's overseeing his personal finances and they find out that they've been misusing them or taking them for personal use, it's going to be a legal issue.
Speaker Summers.
Mr. Chairman, thank you. On in support of the bill. The last time this bill was brought, I was not in support of it. It's a real issue, and I think the good Judiciary Committee took the time, went through it, and created what I believe is a good piece of legislation. But I wanted to reiterate something that the good Vice Chair of Appropriations said, and that issue around vulnerable adults and how we fund issues surrounding vulnerable adults needs to be taken care of. We have some real holes out there in our community. And I know, Mr. Chairman, I'm a bit off the bill, but we do really have some holes out there that we need to try to plug to help these individuals. And I hope in the interim we take a hard look at that. But on in support of this bill, I think the judiciary did good work in fixing this up and addressing a real problem, a real challenge, a real difficult challenge. And so I applaud the good work of the committee.
Representative Provenza.
Thank you, Mr. Chairman. Just for some background, a lot of this can happen. The department can look into this and work with families, but one of the big problems that we've seen is that the money's gone and victim services can't necessarily help them. We can't give their money back. This is potentially, hopefully, a preventative measure. And oftentimes, I think a lot of you probably know your bank, and your bank knows you. And so giving them that opportunity to kind of involve themselves rather than kind of coming on the back end, not being able to do anything. We heard stories that varied. Sometimes it was people that they knew. Oftentimes we were hearing stories about folks who were getting scammed by somebody far away, sending a scam in the mail, over email, whatever. And I think that's where we're going to see the biggest benefit, is just something that most people can understand as a scam, but our vulnerable adults, unfortunately, get caught up in something that they wouldn't have otherwise. And that's where we're seeing money in large sums being sent in the mail. We've heard all sorts of different stuff about folks losing a ton of money, sometimes their entire savings, leaving themselves broke. And so this gets in front of that instead of waiting until the end. So I hope you can support that. And just like the previous speaker, I had a lot of heartburn about this bill. And when it came to interim, I had heartburn. And there were things specifically with liability that I had problems with. I had issues with, is that department the right place to go to? And I think we solved a lot of that. We tightened up our liability issues. And I think that this is really all in good faith. And so I hope you can support the bill. We did a lot of really good, important work this summer.
Representative Davis.
Thank you, Mr. Chairman. Still, the question, I understand the intent of the bill, but the question I have is the person that owns the, i.e. checking account, how do you enroll that person in there? Does that make sense? Do they go to the bank and say, hey, I want to sign up for this Fraudulent Account Protection Act or whatever? That's my question. Thank you.
Representative Craigo.
Thank you, Mr. Chairman. So to answer the former speaker, you don't sign up. It just becomes law. And you don't opt in, you don't opt out because, and we actually talked about that in committee. And one of the reasons is if you have an opt-out provision, and you have the circumstance where you have an elderly, a vulnerable adult, and let's say their kid or their nephew or their niece, they'll just opt them out of the account and then the protection is gone. And so we talked about that, but we just didn't think it was a good idea to do that. And so you're automatically enrolled, so to speak. It just happens. But really and there's multiple layers of consumer protection built into the bill. And I think that's what we got to focus back on. One, the bank has to suspect that there is financial exploitation being conducted, right? Which has a very long list to qualify for financial exploitation. Removing a large sum of money doesn't throw up the red flag. So it has to fit in with that definition. And if you look in the bill, it describes it. And so it's pretty tight on what qualifies for financial exploitation. Once that happens, once somebody at the bank, and it says the definition in the bank, it's a qualified person. Well, that's somebody who works within the bank. And there's a definition for that. And it has to be a qualified person that makes that determination. That person then notifies upper management within the bank and says, hey, I think Mrs. So-and-so is being exploited by her nephew or by the next door neighbor or by somebody, right? Then the bank does a little internal investigation and says, okay, do we think that's actually happening? If they believe that one of their customers is being stolen or defrauded from, they then report that to the Department of Family Services. And there's a reporting mechanism built into the bill as well. Once it goes to the Department of Family Services, they will conduct their own investigation before anything else happens. If they look at it and say, oh, we know this lady, a lot of us come from small towns, right? And so everybody kind of knows everybody. They'll probably know within a matter of hours whether this is a crime or not. It's not going to take the full time set out in this. And last year this bill came to us and the whole period was much longer. I didn't like it. I voted against the bill, and over the interim we worked that down and we got the hold down to a much shorter period of time. And so the bank can only, if something doesn't happen within 5 days, the bank has to get rid of the hold on your account, and you can do whatever you want with your money if that's what you want to do. And within that time, the Department of Family Services can figure out whether something is actually going on or not. And I think I learned a lot. I mean, I didn't like this piece of legislation last year when we looked at it. Over the interim, my mind got changed, and I heard a lot of testimony of why it's needed and why we need to do this to protect some of those people in our community. The banks have no tools to do this. It is against the law for them to hold our account without this piece of legislation. And so they're really coming to us saying, hey, this is something we can do for our folks back home to protect them, and especially those that can't protect themselves. And that's really what we're trying to do. I'd stand for any questions if anybody has any more.
Chairman Washer.
Thank you, Mr. Chairman. I think we all just need to take a deep breath here. Most of us have credit cards that when we got the credit card, we automatically got fraud protection. And I remember the day where I was at the go-kart track in North Platte, Nebraska, taking my kids on a go-kart ride, grandkids on a go-kart ride, and I get a fraud alert saying, this is not typical behavior, right? For some reason, my credit card company didn't think that I would be a go-kart kind of guy. And so they alerted me. And this is basically the same kind of activity, only we're talking about a bank rather than a credit card company. And the banks are the most regulated industry in Wyoming. And they need this authorization in order for them to share information outside of the Banking Privacy Act and to protect our members, right? And our family members and our relatives and other people. So there's nothing really nefarious going on here. We're giving them a brief period of time to take a double check, because sadly what we heard over and over is prosecutions are very difficult because they're family members and family doesn't necessarily want, their relative to go to jail or something. But often by the time these things are identified under existing processes, the money's gone. So what we're hoping to do here is create a circumstance where the bank picks up on early indicators that maybe one or two small frauds have already taken place, intervenes, we do an investigation, find out this is all legit, great, transactions continue. Not legit, we put a hold on it, stop it, so we can protect our family members and friends. This is really good legislation. The 34 other states that have it, no complaints, no nefarious activity, no desire to repeal the legislation. So please say, vote aye.
Representative Hornock.
Thank you, Mr. Chairman. I have a question regarding 13-1705, the immunity clause. And so, you know, I understand that the purpose for this and protecting these people, but there has been a situation over the last, you know, years back where it was actually the banking institution, a large national banking institution that was involved in some fraud. And so I'm curious if enacting this immunity clause within this bill, if it gives complete immunity to those banks who, you know, and granted, this isn't going to happen all the time, that the banks themselves take advantage of somebody. Obviously, that's a really bad deal. But I'm really curious about the immunity clause and if that's standard with this type of practice, or why we would want to have some immunity clause when we're not sure who the right party, the bad guy is in the situation. Thanks.
Representative Walk.
Thank you, Mr. Chairman. And I'm curious, is this, you say that the banks can't do this. It's interesting, I admit, maybe I bank at a credit union, but my credit union notifies me when there's a transaction that seems unusual. So you say this can't happen, but I think I'm seeing that happen. And then, you know, if a person wants to opt into a process, opt into a security process that brings what they perceive as enhanced security, that's one thing. But to now say, I realize there's this definition of vulnerable adult, there's just a lot of gray area here that jumps right into, you know, somebody can, obviously, since I do get a lot of notices, maybe that means my banking transactions are inconsistent. That being said, maybe I'm the king of chaos. There's just a lot of open territory here, and that's where my concern is.
Perfect. Representative Stiff.
Mr. Chairman, thank you. I did have a question about the immunity clause for members of the committee, perhaps. Was there discussion in the committee about whether the immunity would be absolute or whether it would be qualified based upon the financial institutions acting in good faith? I just want to know if you talked about that.
Representative Jennings.
Thank you, Mr. Chairman. So this piece of legislation is one of the few things that have brought me around to the conclusion that zombies do exist. I have seen this piece of legislation numerous times, and it has died each time, and once again, here it is again. And I agree with the good speaker. There is a problem that needs to be addressed. There are people out there that get scammed. There are both from a mental capacity and also from age. Sometimes there's things that occur, family. Sometimes it happens from a long ways away. But my problem with this is there's a number of things. When we talk about credit cards, we choose whether or not to get that credit card, and they choose to put that in there, put that protection in there, and they begin tracking or profiling our transactions, our financial transactions as they occur, so that they can figure out that we might not be the go-kart kind of guy. And we sign up for that. In this case, and I have a couple of things. I'm going to tie the two together. One is for prosecutions. It's almost non-existent. What's against the law now? It's called fraud. And in the 34 states that have done this, I think I would feel more comfortable if I knew that we had taken care of all scam and fraud issues. I hadn't heard anything about their amount of fraud going down. So I'd like to hear some statistics on that, although in our state, when I asked the question, how many prosecutions, there were 22 ongoing at one point in time, 0 prosecutions, 0. So I'm really resonant to want to pass another piece of legislation to feel good about, because we can take up several pages in the green books. But then I also return back to the banking side of this, and I think to myself, vulnerable adult. We're going to ask a banking, maybe not a teller, but maybe a next level up or someone, to make a decision. I take you to page 3. And we're going to ask someone to make a decision on a vulnerable adult that someone is a bad actor, they're attempting to obtain control. Well, that's sometimes hard to tell with people that we know, that they're trying to obtain control through deception, intimidation. Very few people going through the bank line are going to have someone there trying to intimidate them. Fraud or undue influence over the other person's money. That's the end result. That is what happens. But we're going to ask someone in the financial loaning or financial institution to make a decision on whether or not someone's being intimidated. They're not in their home. The intimidation happened out in the car, or it happened somewhere else. I don't deny that we have a problem here. I'm just saying and then we're going to give the financial institution immunity. We're asking them to do something we don't even give police officers or law enforcement the right to profile other people's stuff without a warrant. But we're going to do this financial institution and ask someone to do that. Now, I'll grant you that there is a huge problem here. I'd sure like to see some prosecutions before we go down this road.
Representative Crago.
Thank you, Mr. Chairman. I'll be quick. I just wanted to address the immunity thing. It does have a qualification on there, and if you look at the language in the bill, which we put in, it says it only applies unless the qualified person or financial institution acted in bad faith or malicious purpose. So if your bank is messing around with you, the immunity clause doesn't work. What it's saying is they can provide the information to DFS. That's really what we're providing the immunity clause for, because without that, they can't do that. They can't provide your banking information to somebody, including DFS, without that waiver.
Representative Olson.
Thank you, Mr. Chairman. I just wanted to kind of add on to the immunity concept, and really what I look at is the hold itself. The bill itself allows for a 5-day hold. So what you're doing is granting immunity for the first 5 days. You're saying, well, something, if we got it wrong, if we thought we were protecting a vulnerable adult and we weren't, then what could go wrong in the 5 days? And we're not going to hold the institution liable for what did happen in the 5 days. Honestly, that's pretty minimal. So then let's go to the next step. The next step would be the 30 days, because you can get an extension if it's under investigation for a full 30 days. I suspect the reasoning behind 30 days is because if you had bills that were due and you weren't able to access your bank account because there was a hold placed on it, those come due every 30 days. So that's why 30 days is the magic number, because if you're going to go beyond that, you're going to have to actually get a court order to go beyond 30 days. So what's the real harm that's going to occur if the bank gets it wrong? The harm is going to be a missed payment on a vehicle, or a missed mortgage payment. In order to default on a loan, usually you have to have 3 to 6 consecutive months of missed payments. So I don't think the immunity is really a big concern, because we've narrowed that by saying the longest you can have this hold on the bank account institution is for 30 days, unless you get a court order otherwise. And I think once you get to the level of getting the court order, I think you're going to have a really high showing that there is fraud and that you need the hold, because the court's not going to willy-nilly just grant extensions beyond those 30 days. So I don't know if that helps anyone, but it sure brings me comfort when I look at the maximum amount that the hold could be is for 30 days. The immunity doesn't bother me as much.
Representative Oakley.
Thank you, Mr. Speaker. I just as soon go last. I don't, if
Representative Knapp.
Mr. Chairman, thank you. Boy, this is an issue that faces all of us. I have two elderly parents, and I spend most of my time that I'm not here just protecting them from themselves sometimes. So I just had a couple questions, because I do like the idea of trying to protect our seniors. It's a balance that our family deals with because of the definition of vulnerable or the definition of capable sometimes. Purchases can be all over the place, or people can be helping out another person, and certain bank transactions that we feel are not sound and safe may feel that it is to them. And that's a personal right and a personal freedom. It's their money. So it's a fine balance between respecting our seniors and their ability to conduct business the way they see fit, and protecting them from fraud and abuse. So the question I had is wouldn't it be possibly better to have an opt-in policy with this, a voluntary policy? Because holding somebody's account 4 or 5 days in some cases is a big deal if they're on vacation and can't have access to their money, and they're limited in money. With a credit card, it's a little bit easier, right? With a credit card, they call you immediately or text you if there's fraud. You immediately call them back or text them back. They open up your card again. You explain it. It's easy. Some banks that I've dealt with, because I've dealt with a lot of banks in my life, and for long periods of time, like 30 years. And so some of them will call you and say, hey, your dad was down here. We just want to make sure this is a proper transaction. There's other banks that are more national who have their own policies, and given the opportunity to hold your account for 5 days, they don't care what excuse you have. They don't care to look into it. They will freeze your account, and it's very difficult to get it open and conduct business again. So I think it's important to have that voluntary aspect, and I would ask that question of the bringer.
Chairman Washit.
Thank you, Mr. Chairman. With regards to the opt-in, the concern there is today you're healthy, vigorous, you're a fine person, you don't see any need to opt in. Tomorrow, you slip on the ice, you hit your head, now you have an acquired brain injury, now you're a vulnerable adult, and the opportunity to get signed up may have passed. And so the same way when you get your credit card, and your credit card has built-in fraud protection, we're building in fraud protection in the statute for these vulnerable adults. The worst that can happen is the bank can hold your money for 5 days while an investigation is undertaken. Only if that investigation reveals cause and they get a court order and so forth, will that delay extend beyond 5 days. That's the maximum. In most of these cases, in most of our communities, it's going to be hours, maybe a day. But we put 5 days in to deal with Thanksgiving weekend and those sorts of things where maybe we need some more time, or we got to get hold of somebody who lives out of state. So 5 days, the worst that can happen, we asked this question, what's the worst that can happen? And what's worst that can happen is a missed opportunity, right? Maybe you want to buy that super duper pickup truck that's on the lot, haven't had one in months on the car lot. Now you see one, you want to buy it, the bank thinks there's something going on with the transaction, holds the money for 5 days. Maximum 5 days. To me, that's a valuable trade-off to protect these vulnerable people who are literally losing everything. When we asked about building in protection through the victim services program and building in some ability to reimburse our victims, we were told you're going to have a lot of money to cover these losses, because people literally lose everything. And when the money's gone, catching the bad guy and putting him in prison, kind of a hollow success story, right? Because grandma still lost all the money. Please vote aye.
Speaker Summers.
Mr. Chairman, my apologies for speaking twice on this, but I had the director of that program that takes care of folks with sexual assault and violence talk about and I get emotional on this, talking about an adult who was living in feces, dog poo, while the people in that house were spending their money on drugs. And you're going to say we can't go down the path of trying something? What we do is try things. If we screw up, we'll fix it. That's what we do. We're the Wyoming legislature. On and for this bill.
Representative Oakley, let's bring her home.
Thank you, Mr. Chairman. So appreciate the good discussion, but to bring it back in on what we're really looking at here. Basically, if you look at this, the banks came to us and said, look, we're in the best position to possibly alert somebody that something nefarious is going on. And we can stop a tragedy before it takes place. This is basically, our banks came to us and said, we can provide a service because a lot of this isn't noticed in time. It's too late. And so normally what we look at, you think of law enforcement investigating. Well, they're saying, look, we can find that that something nefarious is going on, and we can talk to DFS or law enforcement. That's also, again, another thing I would encourage everybody to do is read the bill and what it does and does not do. And it allows that. So anyway, it allows the policies and procedures to be put in place. There's really no negative side to this other than a possible fraudulent transaction being stopped. And if it's not, then it'll go through. That's it. That's all this bill does. So with that, I'd ask for your aye vote.
Question having been called. All those in favor of Chairman Waschitz's motion that when the committee of the whole rises to report to do so with the recommendation that Senate File 24 do pass, all those in favor say aye. Aye. Those opposed, no? No. The ayes have it. Senate File 24 has passed the committee of the whole. The next bill for your consideration is Senate File 26. The reading clerk, please read the bill.
Senate File 26, sponsored by Labor, Psychology Interjurisdictional Compact, an act relating to professional licensing. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 26, Psychology Interjurisdictional Compact. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Klauston, O'Hearn, Yin, Sewanitzer. Noes, Representatives Hornock, Penn, Trujillo, Ward. Representative Sewanitzer, Chairman.
You've heard the motion. You've heard the reading of the bill. Chairman Zwanitzer, what's your pleasure?
Thank you, Mr. Chairman. I move when the committee of the whole rise to report to do so the recommendation that Senate File 26 do pass. There are no standing committee amendments, and my committee voted on me to present the bill. So I will try to be quicker than the last bill. Senate File 26 is a compact bill for the Psychology Interjurisdictional Compact. So we have, just under 40 compacts right now in state law where we offer reciprocity with other states to allow, in our Practice Act and their Practice Acts, those medical providers in many cases to be able to practice. This is similar. This would allow psychologists outside of Wyoming to use telemedicine, or you can have a limited patient relationship through psychological means on one-on-one in person for limited amounts of time. Think about cross-border areas or students who attend school here and then go back to their home of residence. They can stay with the same psychologist. 34 other states are part of this compact. It's commonly called PsyPact. 8 more states have it on the books this year to try to get passed. Again, the Board of Psychology oversees our portion of psychologists in Wyoming and would administer our portion of the compact in line with the 34 other states. Be happy to answer any questions on it. It is one of those bills that the language has to be the exact same among all the states for the compact to work. So please don't amend it, but I'd be happy to answer any questions.
Representative Ward.
Thank you, Mr. Chairman. I was one of the members of this committee and I voted no, and I'm going to explain. If you look on page 57, starting with line 1, it says, upon determination that an emergency exists, the commission may consider and adopt an emergency rule without prior notice, opportunity for comment, or hearing. And then if you look at number 1, line 11, in order to meet an imminent threat to public health. This harkens back to the last 3 years, and I'm very uncomfortable with this language. Furthermore, this is pushed by the association that cares about psychology nationally, and that association has things on its website. I'm going to give some examples. Sex Ed for the Stroller Set, How to Have Honest Conversations with Young Children. It's the title of one of the books they recommend on their website. Trans Plus, Love, Sex, Romance, and Being You. Jacob's School Play, starring he, she, and they. This is pushed by...
Point of order. What's your point?
Thank you, Mr. Chairman. None of those things my fellow representative was listing off has to do with this bill specifically.
The organization with those things on their website is pushing this
Wait,
bill.
stop.
It's relevant to the bill.
Representative, you have to address the chair. And
Mr.
with that,
Chairman.
what I would say is let's stay on the bill.
I would conclude my comments. My comments are relevant to the bill.
Representative Henderson.
Thank you, Mr. Chairman. I just want to share some information with the body. There's a couple of things I want to share very quickly. About 6 years ago, in my first term, I was offered the opportunity to go to the city on the east where we all call the swamp. And one of our organizations that we're a member of offered the opportunity to bring several people who know what they're talking about in the important field that we're discussing today. And it had to do with this compact. At that time, there were 4 states that were members of the compact. There's a minimum of 7 required, and over this period, we're up to, I think the chairman said, 34 other states. And so simply what this is it enable us as Wyoming to have, because of our rural nature and our limited healthcare infrastructure in certain areas, so that if you have a family member who's benefiting from a real productive relationship with one of these professionals, and then that professional, for whatever reason, moves to another state, then this compact enables them to be able to get that care and continue that productive relationship across jurisdictional boundaries. And one of the areas, for example, that this helps with, is the billing process, because every state doesn't have the same waiver. And what I encourage you to do is realize that this is just simply an agreement of reciprocity. The following example happened during the last period, and it's related to this because it's mental. A lady in my district had stage 4 cancer and was worried about being able to talk with her provider in another state to the south of us. And our good medical board was able to set her up through a process that they have to enable out-of-state providers to become certified. Did you know we have almost 5,500 out-of-state providers who can provide these good services across state lines via a secure link to the people in our state who need that help? So there's a lot of pages in this bill, but this is not that complex. So I just would ask you to consider that. Let's move it on. We can certainly bring up amendments, and I sure would call the question. Thank you.
Representative Stivar.
Thank you, Mr. Chairman. Right now, there are 34 compacts within statutes. I had the LSO do this sheet for me. I'm not a big fan of compacts. They hamstring the state on further legislation that we want to do. The unintended consequences that these things can bring up is a problem.
We need to vote no.
Representative Clausen.
Thank you, Chair. I'd just like to address the emergency clause in here. So with the other compacts, when this happened across the country, the emergency change was that you didn't have to get as many continuing education hours because you weren't allowed to travel and do that kind of thing. The other thing we need to realize, before COVID, telemedicine was doing about 14,000 visits a week. In December, the United States was doing 10.1 million telehealth visits per week. This, we heard testimony from a psychiatrist here in town that he works with the military and he has top secret clearance. But because he's not licensed in other states, when some of his clients get transferred to a different Air Force base, he can't keep taking care of them. So here's a professional that they know, that they trust, that they have a relationship with, and he can no longer take care of them. So things like this, Wyoming has 30 to 40 compacts, allows better continued care for our people. So I would ask you to please be supportive of this compact. Thank you.
Representative O'Hearn.
Thank you, Mr. Chairman. I'm a fan of compacts because in the smaller towns that can't have these kind of individuals living them because they can't create a big enough base of clients, they can get online. And like the previous speaker said, telemedicine has helped that a lot, but it hasn't fixed all the problems. This compact will help make that better on and for the million.
Representative Heiner.
Thank you, Mr. Chair. My daughter is a therapist in another state. She deals with crisis situations all the time in her profession, and she works with individuals that on a face-to-face basis. But when it comes time that she wants to take a vacation, it creates a crisis in the lives of these individuals that she is working with. They are so scared of not being able to meet with her when they have an issue. But because the state which she practices in has reciprocity with other states, I've been on vacation with her and her husband when she has been able to dial in and have a session with these individuals and talk them back off of a cliff. We talk about mental health here in the state of Wyoming. We talk about suicide rates, which is a crisis that we have. If we want therapists and psychiatrists and those people that are there to help to be engaged with these people that have emotional crisis, we can't expect them to always be able to do face-to-face meetings. They have a life of their own as well. They have to be able to dial in and help when the time comes. And they love their clients. They want to help. That's why they went into this career path. But they can't be chained to the office all the time. This allows individuals like my daughter to be able to go on a vacation and still take care of those individuals that they love so dearly through the technology that we have, through Zoom meetings, to be able to stay in contact with them. So by them taking a vacation, it doesn't create a crisis in their lives, which could be detrimental. I urge you to vote aye on this bill. Thank you.
Representative Locke.
Thank you, Mr. Chairman. Just a quick question for those of us who don't know this space at all. Are these people able to license across multiple states? And the second thing is this licensing process, is it cost prohibitive, for example, to license in multiple states? I'm just learning the process. Thank you.
Representative Ward.
Thank you, Mr. Chairman. Yes, we did discuss that in our committee in answer to the good representative's question. Yes, psychologists can be licensed across state lines now, currently. If they're licensed in those other states, they can provide telehealth without this compact. Thank you.
Chairman Zwanzer, are you there?
I'm here. Thank you, Mr. Chairman. So yes, you can go get licensed in multiple states. but understand that that requires a large amount of payment, and that each state who's not now in this compact, and as I said before, 34 states now are, they can have different requirements for continuing education is usually the big one, that different states have different requirements. So you still want to be licensed in your home state, whatever the state closest to yours or you want to reside in, and then have these agreements. Again, most of you know that about 80% of our population lives within 50 miles of a border. And so we do have a lot of people crossing state lines who are seeking mental health services on both sides of the border. I think I mentioned the University Town previously, but certainly a lot of our small communities have larger communities within 100 miles on the other side. It was mentioned this bill is encouraged and quote unquote being pushed by the American Psychological Association, which is mentioned in the bill. And so they're strongly in favor and they have a process set up. I think I answered almost all the questions, right? We all just know psychology is tough. People have some pretty tough issues out there, and we have a huge need for services to deal with some of those complexity of these issues. It doesn't, I mean, not only helps our people get services that might not be provided in Wyoming, it does and can also help our providers here in Wyoming deal with clients in other states. And so I think it's a win-win for the people of Wyoming and for our psychologists who want to be able to practice, especially in our neighboring states. All of our states to the east, west, and south are already members of the compact at this time.
Representative Davis.
Thank you, Mr. Chairman. I had an email, they call it, I guess. If the state of Wyoming is not getting what they, quit smiling back there in the corner, I don't know. But if they're not getting the results that we think this compact is offering, how do we get out of this compact? What is our out on it? Are we bound to it forever, or can we opt out of it again?
Chairman Zwanzer.
Thank you, Mr. Chairman. I think the quick answer is just this body would opt us out statutorily, legislatively if needed. I don't believe we've had a question on our other 34 compacts in my 20 years about eliminating them. They seem to be they're very worthwhile for the state of Wyoming with our low population, the amount of services we can help get into our state, and a wide variety of these compacts now. So, but that would be the answer, is it would come before the legislature and we would take ourselves out of the compact. Similarly, the Board of Psychology could, with notice, I think it's somewhere in the early 40s in the bill, take themselves out of the compact, or our licensees out of the compact with advance notice and some stipulations in the bill. So they could also kind of de facto stop the compact internally, but certainly this body could come take out the compact any year we wish.
Representative O'Hearn.
Thank you, Mr. Chairman. No psychologist in the state or any state has to join a compact. You can stay in your own town. You can do your own thing. This just enables more people to get more help. And there's a big mental health crisis in the country today. On and for the bill.
Question having been called. All those in favor of Chairman Zwanzer's motion that when the committee of the whole rises to report, it do so with the recommendation that bill number, Senate file number 26 do pass. All those in favor say aye. Aye. Opposed, no. Senate file 26 is passed committee of the whole. The next bill for our consideration is Senate file 28. Reading clerk, would you please read the bill?
Senate File 28, sponsored by Tribal. Livestock, infectious disease control, tribal inclusion, an act relating to agriculture. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred Senate File 28 engrossed. Livestock, infectious disease control, tribal inclusion. Respectfully report, same back to the House with the recommendation that do pass. Ayes. Representatives Alaman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman.
You've heard the reading of the bill. Representative Eklund, what's your pleasure?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 28 do pass, and I'll turn the explanation over to the chairman of our Select Committee on Tribal Relations from the land just east of the winds.
Representative Larson.
Thank you, Mr. Chairman. One of the things that your Select Committee on Tribal Relations does is try to interface with state agencies and the two tribes on issues that impact the whole state. And one of the things that we've dealt with, particularly on the Livestock Board, is brand inspections, rustling, things of that nature, in trying to integrate what we do in the rest of the state within the boundaries of the reservation, which are considered to be sovereign for the two tribes that are there. One of the issues that we studied for a couple of years is how do we better enforce the designated surveillance area for brucellosis and other infectious diseases. One of the ways that we monitor that, where in the Wind River Reservation is on the border, and it's kind of goes into that designated surveillance area, is you test your livestock to make sure that they're not carrying, and you also periodically test wildlife to make sure that you don't have any of those carrying elk, buffalo, things of that nature. Our department over Fish and Game take care of that testing around the rest of the state, and on the reservation is between the tribe and the federal agency that oversees that. So then trying to kind of come to an agreement on how we could better protect the livestock industry as a whole by including testing on the Wind River Reservation. One of the proposals that came forward from the Board of Livestock and the tribes was to allow those livestock producers on the reservation to participate to participate in infectious disease programs. And so that's one thing that this does. And as part of that requirement, in order to participate, they have to be willing to test their livestock, make sure that they do everything else like those other requirements around in the DSA, the designated surveillance area. The second component of that is it would give authority to the state to enter into an agreement with the tribe, should they ever want to do that, to require to, if the tribe wanted to require that of their own, that then again that this would be available to them. So that's what we do on page 2, and then we spread that out through the programs for brucellosis and tuberculosis in the bill. So, Mr. Chairman, with that, I'd be happy to answer any questions.
Any questions? Question having been called. All those in favor of Chairman Eklund's motion that when the Committee of the Whole rises to report, to do so with the recommendation that Senate File 28 do pass, all those in favor, please signify by saying aye. Aye. Oppose, no. The ayes have it. Senate File 28 has passed Committee of the Whole. The next bill for our consideration is Senate File 33. Reading clerk, would you please read the bill?
Senate File 33, sponsored by Judiciary, defining aircraft for purposes of hunting prohibitions, an act relating to game and fish. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred Senate File 33, defining aircraft for purposes of hunting prohibitions. Respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Alaman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman.
You've heard the reading of the bill. Chairman Eklund, what is your pleasure?
Mr. Chairman, I move that when the Committee of the Whole rises to report, it do so with recommendation that Senate File 33 do pass, and I'll turn the explanation of the bill over to our member of the Ag Committee as well as a member of the Judiciary Committee.
Representative Crago.
Thank you, Mr. Chairman. Members, I bring to you Senate File 33 and ask for your favorable consideration today. So over the interim, Joint Judiciary looked at a lot of things. One of the topics we dealt with was drones. And so as we were doing work on drones and drone trespass and whatnot, the topic of this particular bill came up, and that is defining aircraft within the game and fish statute that prohibits the use of aircraft for hunting, scouting, et cetera, as part of the hunting process. And we figured out that it really doesn't include the definition, doesn't include drone. And so this bill is just an attempt to tighten up that language and actually define the term aircraft within this section and this section only of the statutes. And so that's what it does. As you see at the end of the bill, the very last couple words there talks about unmanned aerial vehicle, and that's the technical definition for a drone. So I'd stand for any questions.
Any questions? Seeing no question and having the question being called, all those in favor of Chairman Eklund's motion that when the committee of the whole rises to report, it do so with the recommendation that Senate File 33 do pass. All those in favor, please say aye. Aye. Opposed, say no. Senate File 33 has passed committee of the whole. The next bill for our consideration is Senate File 36. Would the reading clerk please read the bill?
Senate File 36, sponsored by Capital Finance. Investment Funds Committee, Selection Panel Amendments, an act relating to the investment of state funds. Mr. Speaker, your committee number 2 appropriations, to whom is referred Senate File 36. Investment Funds Committee, Selection Panel Amendments, respectfully report, same back to the House, with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Walters. Noes, Representative Zwanitzer. Excused, Representative Stith. Representative Nicholas, Chairman.
Okay, so you have heard the reading of the bill. Chairman Nicholas, what is your pleasure?
Thank you, Mr. Chairman. I move when the committee of the whole rise and report, it does so with the recommendation that Senate File 36 do pass, and I will explain the bill for the floor. Ladies and gentlemen, this is basically it's a technical correction or amendment to the mechanisms by which we select new members of the Investment Funds Committee. For those of you who don't know, the Investment Funds Committee was created back in about 2018, to be a member. It's a 7-person committee. To be a member of the Investment Funds Committee, you have to have at least 7 years of experience in managing in portfolios over $500 million with a broad understanding of the financial markets. And so this committee was created through the work of our state treasurer and also our chief executive to develop volunteer expertise of the best, of the best and the brightest from the financial world to help provide advice with our managing our portfolios both in retirement and in the state treasurer's office, which combined now altogether are over $25 billion. And so then when we lost a member of the IFC, we went 4 or 5 months without having a replacement because we hadn't created a mechanism statute to replace an IFC member. And so all this does is adopt. And so, by the way, the IFC members are selected by another panel because it's kind of a double blind to make sure that it's not a political appointment, that you find the most qualified people to do this. And so you have other folks who are the selection panel who are also qualified experts who then will select the panel members for the IFC. And so what this does, with that selection panel, it requires that that selection panel must perform the work that they do in finding a replacement for the IFC member within 60 days. And basically, that's all this bill does. And I'd be happy to answer any questions.
Any questions? Seeing no questions and having the question being called, all those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report, it do so with the recommendation that bill number, Senate file number 36, do pass. All those in favor say aye. Opposed, say no. Senate File 36 is passed the Committee of the Whole. The next bill for our consideration is Senate File 39. Would the reading clerk please read the bill?
Senate File 39, sponsored by Revenue. Board of Equalization, questions before the board. An act relating to the State Board of Equalization. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 39. Board of Equalization, questions before the board. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. Chairman Harshman, what is your pleasure?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 38,
39.
do pass. There are no standing committee amendments, and I turn the explanation of this bill over to the good representative from House District 43.
Thank you. Representative Zwanitzer, Chairman Zwanitzer.
Thank you, Mr. Chairman. Pleased to present Senate File 39, the Board of Equalization, questions before the board. The Board of Equalization, for those of you not familiar, is our constitutionally created body of 3 people who ensure that valuation and our taxation is uniform throughout Wyoming. And so primarily what they do now is they hear appeals from taxpayers against the Department of Revenue and settle disputes. We had a case from Southwest Wyoming a couple of years ago, went on a 3-2 decision into the Supreme Court. And the question was, if 2 parties come before the board and they present their sides of the dispute, and the board knows that there is more questions that deal with valuation above and beyond what both sides present, can they take into account other information they know, other statutes, other case law into that decision? The Supreme Court on a 3-2 decision said they didn't have clear statutory authority to do so. So what this bill attempts to do is give them that kind of clear authority, as long as it's in their adjudicative and regulatory functions, to be able to decide those questions and look at other issues that may not have been presented by either side. In my thought, either perhaps intentional, perhaps negligence, or perhaps they just don't know that there were other statutes that affected the taxpayer at a greater level than was presented. Happy to answer any questions.
Representative Stith.
Mr. Chairman, on and against Senate File 39. The operative language here is on page 3, starting on line 8, provides that when deciding questions under this paragraph, the board may address issues not raised by the parties and is not limited to the legal interpretations presented by the parties. So the question is, do you want your board that's sitting in an adjudicatory role, that it's deciding a case, do you want it to act like a referee trying to decide between the parties, or do you want it to also act like a player? And in our adversary system, the way we have things set up is that the lawyers are there in the courtroom or before an adjudicatory body playing the game, and the adjudicatory board in this case should, in my view, act as a referee. It would be like, and here's the part of the problem, is that if the board is allowed to just raise new issues, then the lawyers, they're getting ready. It's like they're preparing for a big basketball game. They've been practicing, they're going up against each other, they're all prepared, and they get there, and then suddenly the referee says, well, we're not playing basketball, we're gonna play soccer instead. Or it would be as though during the game, the referee thinks that one of the players isn't doing a good job and says, hey, you get some extra free throws because you're not doing a very good job. So it's that danger of having the board tilt against one party or another and become, instead of being a neutral adjudicatory board, instead being a player that sort of rubs me the wrong way about this one. So I stand in support of our highest court and its ruling from 2018 that said that this board does not have the power to do that. So thank you.
Representative Chestick.
Thank you, Mr. Chairman. On and in favor of the bill as written. I do take the good Speaker Pro Tem's point that there are 2 choices here. The board can be either a neutral referee or a player. But I think in this situation, they do need to be a player, because the role of the State Board of Equalization is not to administer justice. That's what courts are for. It is to equalize tax throughout the state. And if the parties to the dispute, for whatever reason, don't want to, or either neglectfully don't raise issues or collude not to because they have other interests, I think it's important for that board to look at the broader picture and look at the statewide implication of any decision to make a statewide equalization. I believe there's an appeal from the equalization board to the court at some point. If the board decides something, either party can take it to the court where they would be the neutral arbiter, but at the level of the state equalization board, I believe they have to be a player and look at the interests of the state as a whole, and therefore I'm on and in favor of the bill.
Representative Crago.
Thank you, Mr. Chairman. As somebody who actually practices before the Board of Equalization occasionally, they are an adjudicator, if I can use get the words right in my mouth. They make decisions and lawyers make arguments to them. They act more like a court in that particular circumstance on appeals, either from the decision of the department that handles all of our revenue or from the county boards of equalization. So at that point, they're not necessarily equalizing value across the state. That's a different procedure and a different job that they have to do. And that has to do with county assessments on a statewide level. And they do that, but this is a separate, what I believe is a separate function within that department, just so everybody knows where we are, that those are two different things. And when I write a brief to them and my opponent writes a brief to them, one of us gets a reply, one of us gets just like a standard court. You go there and you make oral arguments. It's similar to an appellate court when you go there from an appeal from the county or an appeal from the State Department that handles all of our revenue. And so I'm a little bit, troubled by the bill. I'm not going to say necessarily for or against, but I'm a little bit troubled. And the reason being is we're essentially saying, lawyer, if you didn't make the right argument, it's all right. We'll make it for you. And this is the only place I know that happens. If I go to court and I fail to make an argument on behalf of my client, that's my fault. And the court's not going to jump in and say, oh, we're going to bail you out, Mr. So-and-so from House District 40, and make sure that the argument gets made. If you don't make the argument, it doesn't get heard at the appellate level. If I go to trial and I fail to make an argument, I have waived that argument. And so I'm a little bit troubled by that because I think we're maybe creating a different precedent outside of normal practice within the legal profession. And I guess it's something to think about as we move forward.
Chairman Zwanzer.
Thank you, Mr. Chairman. So the question is, what happens if you intentionally don't make the argument, right? You're not going to allow the board to take in other information to make a decision. So this isn't a criminal or a civil usual, when we talk about the court and their procedure, right? The Board of Equalization, this quasi-judicial role, they're responsible to the taxpayer, to us, to all of you. They're responsible for getting it right and correct the decision because it affects everyone, right? More than maybe a plaintiff versus a defendant. And so let's say one side's negligent, they don't bring up a certain argument, they don't want to quote a certain statute, but the board knows they should have. The board should be able to say, neither side mentioned this area of tax law. We're not sure if it was purposeful or not, but it's incumbent on them as the state board to ensure that they are able to look at all facets before they make a decision, right? It's similar to maybe more like another quasi-judicial body like the Public Service Commission, right? 3 appointed members. And so I guess those are my points. Their ultimate job is not necessarily, hey, pick a winner and a loser. They certainly do that. Their ultimate job is to look at the complexity of all the laws and say, we're making sure we're doing this right, and we need all the information in this realm, right? There's still some, the sideboards when it just comes to their adjudicative and regulatory functions. But the question, and I would say they assumed they had this until it was an appeal and the court said, well, we don't really see it spelled out anywhere. So that's why they brought it to us. And so I'm sure the good attorneys can disagree, but I do think the board's ultimate purpose is to get it right to the taxpayer across Wyoming, and they need this power in some case to be able to say, neither side brought the information, but we know it exists. We got to utilize it to make a decision. Otherwise, they're not making the best decision possible. And I think that's what the real crux of the argument is. We want the Board of Equalization to get it right. And to get it right, they need to be able to access what they know they can use to make those decisions.
Representative Hornock.
Thank you, Mr. Chairman. One thing I wanted to point out is one of our good lawyers just referred to themselves as adversaries. But beside that point, how would the board gain this information? So that's where I would be a little bit nervous. If you're in a court setting and the attorneys bring information to both sides and the Board of Equalization goes out and seeks further information, how are they going out and seeking that information? How do they go beyond what the attorneys bring them in this case to gain further information? I would want to know if they have that power generally and are able to even do that. Thank you.
Representative Knapp.
Mr. Chairman, thank you. I just had a question. Just having served on boards of equalization, there's already an assumption that an assessor's information based on the CAMA system is correct. It's the burden of proof for the applicant to rise above that. And so my question is, isn't there already an outside weight in the decision based on the CAMA system?
Representative Craigo? Are you, no? Representative Chestick.
Thank you, Mr. Chairman, and I do admit that I have never practiced in front of the State Board of Equalization in Wyoming, but in my prior life as a lawyer in Pennsylvania, I did practice in front of similar boards in Pennsylvania. In fact, for a period of time, I was the lawyer for one of those boards. When we had a dispute, the parties made their arguments, and then the board looked at me and said, what about the law? What is right? And the board also looked at what they had done in other cases. Their job was to look beyond more than just the two parties in front of them and look at the entire county or the entire region, to the extent that a property evaluation goes down in one case, it goes up for everybody else. So they do have a purview well beyond just the two parties in front of them. So for that reason, I'm still very much in favor of this bill.
Chairman Zwanzer.
So just to answer some of those questions, right? So these hearings are normally between your taxpayer and your Attorney General's office who's representing the Department of Revenue in a contested case. And so most of these cases, they're not, oh, my property taxes are too high, I want to complain and let's go to the State Board of Equalization. Most of these cases we're talking about where the statute's coming into effect are these multi-million, billion-dollar industrial companies, mostly in our mining sectors or our other commodities, oil, gas, coal, bentonite, soda ash, right? And they're highly complex when it comes to taxation, and there's a myriad of rules at the federal level, the state level, their local assessments. And so they're trying to figure, did they pay the correct amount of taxation when you take in rebates over there and subsidies and all sorts of a myriad that keeps, very large accounting departments very busy. So that's when these come into play, when the board knows that there's more rebates over here. They didn't take into account, some 3-year average on the right side. That's the kind of cases we're talking about here. These super highly complex ones where you usually hire some very high-powered attorneys. There's a couple of firms in the state to take on the AG's office, right? And so that's where this case stemmed from. That's where the testimony we heard in the interim came from, is these super complex, multi-jurisdictional tax more than would make anybody comfortable. and they say, hey, there's some more stuff you didn't take into account, plaintiff or defendant, in this case, taxpayer or department, and you did all these figures and all this quantifying over here, but as we're looking through and they have their own, rate people, and they're going through all this and they're saying, oh my gosh, they missed that there's an argument over the rebate for whatever the soda ash industry was. So that's what we're getting into here, is do we allow the Board of Equalization to take the entire realm above and beyond what's presented to them in a tax dispute case, which in these cases are millions of dollars? Or do we say, well, if one side didn't bring it and one side didn't present it, can we not take that into account? And so I would continue to submit to you, we want the Board of Equalization to be able to look at the entirety of all of these laws, make the best decision possible on all of the relevant information. It's not like a criminal case with rules of evidence and those type of things. It's about us, the taxpayer, and the taxpayer of the state of Wyoming, and ensuring they get it right.
Representative Craigo.
Thank you, Mr. Chairman. So I think I actually agree with the good professor from across the mountain that there's a difference between these cases that come from the state department that handles our revenue and the ones that are appealed from the county level. And those are two different things. And I think I acknowledge that. And maybe that's why I'm having a hard time wrapping my mind around this, because as we do appeals from the county level, and that's what I do. I don't handle the state type appeals or the state level appeals. We've already made a record. And so, we've put facts and evidence at the county level. We've done our hearings. It's essentially a little mini trial. Sometimes it's a 2-week trial. It just depends. Some of those can get complicated even at the county level when we start talking oil and gas tax appeals. And so those ones, so I think I agree with the concept that at the state level, maybe we are setting more of a policy, but those appeals, which this bill also applies to from the county level, that's not necessarily what we're doing. And so I don't know, maybe there was debate within the committee on whether this should also apply to our county boards, because they're essentially in the same spot as the state board. It's just on a county level versus state. And so I guess a question for the bringer of the bill, was that ever discussed? Do we give the same right to our county Board of Equalization when they're making these decisions?
4 lawyers, 4 mics. Representative Lawley.
Thank you, Mr. Chairman. Somewhat along the lines of the good representative from across the bighorns for me, and to the bringer of the bill, I'm really confused procedurally, because what we're talking about when you compare it to a trial is there's rules of procedure and it's all laid out. So my confusion is this on a sort of larger scale is I understand what you're trying to do, but what I don't understand is how it will work procedurally. When will the board take this new understanding and information? Will the attorneys involved be allowed to then comment on it and critique it and give a response to it? Or does that happen later and it goes unchallenged? Because I think those things matter. And you could be opening a door that I wouldn't open in a kind of process like this unless we lay out if there's a right of response for the lawyers involved. So kind of process and procedure. I think it's so vague, it's not clear, at least not to me, but thank you.
Chairman Olson.
Yeah, thank you, Mr. Chairman. I want to expand upon those last comments because that's my heartburn with this bill as well, is that the board is an adjudicatory entity that is meant to take arguments for and against the taxpayer and then make a decision. And in what takes place before you get to the board is key, because what takes place is a litigation, an exchange of information. You don't show up to an adjudicatory board or a court without knowing everything that's going to be presented. That's what the attorney on both sides knows. They know what the evidence is. They know what the witnesses are. They know what, if we've exchanged briefs, we know what the arguments are. And so we're prepared. My heartburn is that if the board is allowed to just consider anything in the universe, I have that exact same concern. When do they consider that? Do they consider it when I show up at the hearing? and I've already exchanged all the information that I have, and the opposing parties exchanged what they have, and then all of a sudden I'm presented with new questions that I haven't had the chance to research, that I haven't had the chance to fact find on, that I haven't had the chance to do discovery on, to seek information from the other side, to see how truthful are these questions, how important are these questions, are they supported by evidence? So I think that's where you run into some issues, because the bill, it's just not very specific. It just says on lines 8 through 11, right, on page 3, when deciding questions under this paragraph, the board may address issues. Okay, so now let's think more deeply about when. Does that mean that I've gone to the hearing, we've exchanged arguments, we've finalized the hearing, and the board is now sitting on the information to make its decision, and now it decides that there's other relevant information that it needs to consider? I've already made my argument, opposing counsel's already made their argument, the board's sitting off in a room considering additional information, and then does the taxpayer get another chance to respond to that? This doesn't flesh out a process. So I think if we're going to go down this road where the board is going to become something more of a policy-making board than just an adjudicatory board, then we need to actually, in statute, spell out due process, because right now, there's a lot of unknowns, folks, so it gives me a lot of heartburn.
Representative Stiff.
Mr. Chairman, so the core problem with this bill is that it's tilted against the taxpayer, because when the taxpayer shows up, they're expecting to have a neutral decider of the issues and have the attorneys for the state make their arguments about why they owe more tax. But under this bill, when the taxpayer shows up, they're not fighting just against the lawyer for the state, they're fighting against the decider too. It allows the State Board of Equalization to inject itself not as a neutral decider of the issue, but as an active player that's going to start trying to score points on behalf of the state. So it appears to be tilted against the taxpayer, and that's the part of the bill that causes me grief, and so on and against.
Representative Storr.
Thank you, Mr. Chair. Serving on Revenue Committee, we did have a very good explanation of this bill. And I really think it comes down to this. The Board of Equalization wants to be able to look at the entire statute, not just the parts that perhaps the parties bring to the discussion. And really it's as simple as that. And clearly the decision from the Supreme Court, that was 3-2, said, agreed that the board should be able to do that, but recognized that that was not currently in statute. And what this bill tries to do is just clarify that it should be in statute. Thank you.
Representative Chesing.
Thank you, Mr. Chairman. Let's understand what kinds of decisions are being made by the board. They are not just legal interpretations. They are evaluating evidence and trying to equalize, and it's in the name of the tribunal, equalization. They need to make sure that like properties are being treated alike. And that could involve what kind of valuation method do you use, and if the parties are advocating for one type of evaluation, but that's not the evaluation method that's been used in other similar circumstances, the board needs to have the ability to equalize between different cases. Here's a case where one method was used, and now the parties are arguing for a different method, but that's not the method we've used for anybody else. Therefore, the board should take into consideration the other methods, the other results that have happened from similar cases. And that's something that I think is fair to everybody, not just the litigants in that one case, but to the entire state. Again, because we need to make sure that taxes are equally applied across the board. And we're not going to have a special rule for this case because they had good lawyers. Let's have a result that is fair to everybody in the state, because, as I said, when one person's taxes go down, everybody else's go up, and the board needs to be able to address that problem. Thank you.
Chairman Zwanderser, bring us home.
Thanks, just answer some of those questions, and I'm going to read a little bit about why this is before us based on that case, and I will try to stay within the bounds. But what had happened, right, it was a mineral valuation dispute, and the board discovered the taxpayer, in this case, had not read the entire statute and had miscalculated the value of their exemption, what have you. The board then presented that and said, you haven't taken in the entire statute into account. It was very transparent before both the taxpayer and the department, and said, you know, when you read the whole statute and you take everything into account, there's no deduction being able to be given here. And so the board, very, very transparent, fully briefed both sides of what they were suggesting and said, you didn't do this correctly. And then the board made a decision, which the taxpayer didn't like, got appealed to the Supreme Court, and the taxpayer argued that the board had no authority, right? These are very, very smart, crafty attorneys, said, well, the board didn't really have authority to tell both sides and be transparent that they didn't follow the entire statute. So the board feels it did everything right. It said, hey, you're missing this, presented it to both sides, said, would you recalculate based on this information that apparently neither one of you caught? And then as part of the department agreed, said, you're right, we didn't get this figured out. We got it figured out, but then the case got appealed to the Supreme Court, and the non-department party said, hey, that wasn't right for the board to be allowed to say that there was more information given. So that's where this comes from. The board wasn't trying to hide anything. It wasn't making backroom decisions without notifying. It did everything in its due diligence to be upfront, saying, you're not understanding the whole statute here. Let's work on it together. Then they got their tail handed to them a little bit in court by saying you didn't have authority to be transparent and accountable. That's why the statute is here. I didn't hear all the testimony because I wasn't on the interim committee. I'm just the guy that kind of knows a little bit about the Board of Equalization who got asked to present the bill. So if there is more information needed, I would ask you to at least vote aye today. I will get more information, try to send it out to all of you so you better understand the enjoyment of tax law. And then if you're not convinced that this is the right step on third reading, I can accept that. But please don't vote no today because I can't fully explain or deal with the complexity of all the bill and what they're asking.
Representative Jennings.
Mr. Chairman, body, I'm not an attorney, although I signed up for the apprenticeship a little over an hour ago. It was registered. I was on the interim committee, and with my 1 hour of apprenticeship in attorneys, I'm going to recommend that you vote no. Thank you.
Anyone else? Question having been called, all those in favor of, was it Chairman Harshman's motion, when the committee of the whole rises report to do recommend that bill number or Senate file number 39 do pass, all those in favor, please say aye. Aye. Opposed, say no. No. Chair is in question. All those in favor, please rise. All those opposed? More than 21. Okay. Pursuant to House Rule 6-6, the bill having failed a voice vote, and a pursuant standing division, pursuant to House Rule 6.6, Senate File 39, having failed a roll call vote, is in, oh no, sorry. Roll call vote is required. Chief Clerk, will you call the roll?
Ellamand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Northrup, aye. Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Singh? Slagle? Smith? Stiff? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washit? Western? Winter? Wiley? Yin? Zwanenser Dan? Zwanenser Dave? Speaker Summers? Are there any changes? Closing vote? Bear? Closing vote? Vote closed. 19 aye, 43 no.
Pursuant to House Rule 6-6, Senate File 39, having failed a roll call vote, is indefinitely postponed. And with that, we have a privilege of the floor.
Mr. Chairman, privilege of the floor.
Privilege granted.
Thank you. Members, I just want to introduce a constituent here in our South Gallery, Anna Nebel. She's from Sheridan. Anna, please stand up. She's an amazing person, amazing mother. I grew up with her son, and she works Sheridan Wild Rodeo to make sure yours truly behaves properly. Okay, let's give her a round of applause.
Welcome. Welcome to the People's House. The next bill for your consideration is Senate File 42. The reading clerk, please read the bill. It's not.
Senate File 42, sponsored by Revenue. Taxation of cigars, an act relating to tobacco taxes. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 42 engrossed, taxation of cigars, respectfully report same back to the House with the recommendation to do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strock, Swanitzer. Representative Harshman, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Your Committee Number 2, Appropriations, to whom is referred Senate File 42 engrossed, taxation of cigars, respectfully report same back to the House with a recommendation that it amend and do pass failed in accordance with House Rule 5-4. Ayes, Representatives Henderson, Sherwood, Stith, Walters, Swanitzer. Noes, Representative Larson, Nicholas. Representative Nicholas, Chairman.
You've heard the reading of the bill. Chairman Harshman, what's your pleasure?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rise and report to do so with the recommendation that House Bill 42 do pass,
I further recommend the adoption of both standing committee amendments. Mr. Chairman, I'd like to move and move for a vote on standing committee amendment number 2 from our appropriations committee number 2. Gives the bill a haircut from $570,000 to $265,000. So as the bill is amended now, it will cost less money to administer and reprogram. So we're in support of the appropriations amendment. So I'd call for the question unless there's any debate on that.
Question having been called on, it would be standing amendment or standing committee amendment number 2. All those in favor say aye. Opposed say no. Standing committee amendment number 2 is passed. Now on to standing amendment or committee amendment number 1. Mr. Chairman.
Back on the bill. Thank you, Mr. Chairman and members. So appreciate your vote on that amendment. You just saved $275,000. Now I'd like to turn the explanation of the bill and standing committee amendment number 1, and he'll call for that question when he's ready. They kind of go hand in hand, and turn that over to the good representative from the land where the mountains are tall and grand.
Representative Byron.
Thank you, Chairman. Nice little soft reading bill from the last hour we have here. I think the most important part of this bill is going to be, if you are looking at the engrossed copy from our friends down the hall, the first amendment we made as a committee is we fully got rid of that engrossed copy. So go back to the original copy on your, if you have it pulled up. But members, this is a bill dealing with taxation of cigars and specifically premium cigars. There's a lot of different parts of this bill, but really it's quite simple. And what the committee did is we amended it down to kind of match what online retailers are currently getting taxed, or the taxes, which is 10%. It does define premium cigar, which we were told in testimony is about 12 retailers throughout our state. There are situations where cigars, and this was a learning experience for me, are 10, 20, 30. There was a retailer that said he had up to a $100 cigar. So the committee decided that as a whole, a 30-cent tax on a $100 cigar is not equitable. So we amended it back down to a flat tax rate of 10%. The other important part of this bill is the tax was being paid up front. So these cigars, we learned through committee and testimony, can sometimes sit at online retailers for up to a year. And you can imagine what issues that causes. So the bill also cleans that up, and it conforms and basically clears up the situation where now the tax is paid once the product is purchased. I think with that explanation, maybe the good coach has more, but I'm happy to try to answer questions. I was voluntold to bring this bill, so bear with me as I work through my cigar bill.
Any questions on the amendment? Chairman Newsom.
Oh, I'm not sure it's on the amendment, but my question is, how much tax revenue does the state get from cigars? And does it justify what we now have as a almost $300,000 appropriation to reset the computer systems at the state or at the department that collects those taxes?
Representative Byron?
I cannot answer that exact number right now. This was debated certainly in the committee, and I think that's why we had that quick amendment early on, Representative. And you know, it was a question that the good committee down in revenue we brought up, because to change one line in the system, we found it to be quite expensive, over $500,000. So they did amend it once we brought that taxation. Once we re-added premium cigars, it took it from all retailers down to 12 retailers. So I can say that I confidently think it will certainly in the long run be all right. But yeah, it's a large pill to swallow out of the gate.
Representative Wiley.
Thank you, Mr. Chairman. $265,000 to institute this tax for something that's already being taxed. That's going to take better part of a decade. I tell you what, next time we start taxing, I guess we'll tax premium cuts of meat, premium toilet paper. I'll start running around saying, Armageddon. I mean, this is just a tax that I don't think I can support, and I think this guy just needs to go away, and that's my comment. Thank you, Mr. Chairman.
Okay, Representative Byron, let's stay on
Thank
the
you,
bill.
Chairman. From where the water is sweet and the attitude is poor. I will say, to bring it back in, this is already taxed, folks. This is already taxed. So this is not a new tax. Currently, these cigars are being taxed at 20%. You walk in to your premium cigar shop in downtown, the mountain over the town over the mountain, and you're paying 20% on these cigars. So what this bill does solve one of the issues that was brought up. It brings it down to 10, which I think we as a committee thought was very fair, as if you buy them online, it is 10%. So it gives your local brick and mortar retailers a level playing field. And yes, there's a significant cost, but this is not a new tax. This is actually a tax that we as a committee tried to improve. And certainly our friends down the hall, they wanted a flat tax rate of 30 cents, and we could argue that for days on flat taxes and statute. But certainly with the scale of what some of these cigars cost, we as a committee thought that 10%, we worked this bill pretty hard, was equitable and fair. So I hope that clears up some of the show.
Representative Hornock.
Thank you, Mr. Chairman. A couple of questions first. What is the current tax rate? Are we just taxing these at the current sales tax? So we would actually be increasing what the tax rate is now. And then also, so this bill is not at all confusing to anyone but me. So could you please go through it once again? I know we had an original bill, the Senate amended things, then we threw out the Senate bill, we re-engrossed it, we amended what was amended, we came back with something else. Could you please just walk us through one more time on this, what the bill is, what the amendment does in changing the bill? Thank you.
Chairman Harshman.
Thank you, Mr. Chairman. So this was an interim topic we started last spring, and you find these things with internet sales. So you have two things going on here. You have sales tax, which everybody pays, and they're going to pay that when they buy when that product is delivered to, and these are premium cigar shops. These are a place where you'd go in, maybe like out on the Roosevelt balcony. You have friends of, it's nothing to do with slothfulness or greed. This is really about an experience, and there's a couple dozen of these small business owners in Wyoming. One of them is a constituent of mine, brought this issue forward. So here you have maybe $100 cigar. It's not the sales tax. That's at whatever your sales tax is at your local jurisdiction. 5.43 is the state average. They pay that. But then there's a 20% tobacco tax that we have 3 or 4 different levels of tobacco tax. Cigars fall in to the 20%. Okay, there's 2 problems with this. The retailer, the small businessman in Wyoming, has this $100 cigar, and currently it might sit on his shelf until he gets a customer 90 days later that wants to come in, roll it, tap, work it, it's an experience, and buys it. But he has to remit that 20% to the Department of Revenue the day that it gets to his shop, even though it might sit here. So it's a real cash flow issue for the small businessman. The other problem with the 20% is that you and I can order the exact same cigar, exact same premium cigar online, and we only pay a 10% tobacco tax. So we're hampering the brick and mortar small business Wyoming guy who's raising his kids here, running a business here, and we're giving the guy out of state online an advantage. And so that's all we're trying to correct with this thing, is to help small business in Wyoming. It's not a lot of people, but it's an issue that was brought to us. And so the sales tax is the same, nothing changes. It's the tobacco tax issue and when it's remitted and how much it is. So this is a good little bill. Appreciate your support, and I can't think of another word to describe it, but it's really good.
Representative Provenza.
Thank you.
Thank you, Mr. Chairman. Question for the committee. Was there discussion on the healthcare costs associated with people who lust for $100 cigars or just are gluttonous with what they're smoking? Yeah, I'm just wondering if there are any costs associated with that they were trying to take care of. Thank you.
Representative Byron.
There was some testimony, the good bringer of the question, with this not so good little bill. There was, it's a great bill,
Okay,
but
let's
to
tighten
be
it up, you
serious,
guys.
yes, I can't answer the exact number. There was certainly some testimony from an organization that had an opinion on the effects of the product we're talking about. But to balance those two out, I think would be 62 different opinions. So yes, there was some testimony to answer your question. I don't think it's worth me digging in to try to figure out those exact numbers, but I'd be happy to.
Okay. Representative Henderson.
Thank you, Mr. Chairman. At the risk of incurring the wrath of the good chairman, I'd want to know if you have any information on the number of consumers of these fine, premium cigars.
Representative Byron.
Chairman, thank you. We heard from a few of the specific 12 locations that sell these premium cigars. They did not go into any detail about the amount of consumers that are coming to purchase these products, but there was 12 identified retailers statewide, brick and mortar, that do sell these products. So unfortunately, I can't answer the consumer specific number, but certainly 12 brick and mortars that are affected by this.
Question on the amendment. Having the question on the amendment, you've heard the motion on the standing committee amendment, and having a question, all those in favor of standing committee amendment number 1 to Senate File 42, please signify by saying aye. Aye. Opposed, no. The ayes have it. Standing committee amendment number 1 is passed. Back on the bill. Representative Yin.
Thank you, Mr. Chairman. So question, with the standing committee amendment, we can have a $100 cigar that is a quote-unquote premium cigar, meeting that definition of a premium cigar. We can have a $100 cigar that isn't a premium cigar, and one would have to pay 20% on it, and the other we'd have to pay 10% on it. And I guess the question is, even ignoring that premium cigar part, why do working class cigars have to pay more taxes than premium cigars?
Chairman Harshman.
Thank you, Mr. Chairman. Well, that's kind of an interesting question, Mr. Chairman and members. And I would answer it this way. I don't think this is a issue of, and if you met my constituent who's here today, really brought this forward. He is a working man. And he is in a brick and mortar shop right on CY. I drive by it every day. And so that's really the issue. I think that, and so these are local businessmen, Wyoming citizens, compared to the little pack of 6 cigars that you might get in a convenience store that's owned by someone from Europe. And that's the difference. And that's where your money and the 20% and all that compared to a Wyoming businessman. And so that's the difference, really. We're trying to be friendly and not have some kind of, because right now we have an imbalance in the tax system that does not favor the Wyoming guy who set up shop here and is working to try to build a business. So this is a good little bill. It's not about money. It's not about the state getting greedy and having more money or any of that. But we got, this is a good little bill that I think our committee's really proud of, and we're going to do some good. So thank you, Mr. Chairman. Appreciate your vote on the standing committee amendment, which returns the bill to its original format. Because I think our friends down the hall opened this thing up. They open it up to all these multinational corporations who sell you the little six-pack of little cigars with a plastic tip. We're talking about real Wyoming connoisseurs, business brick and mortar. And so let's vote for those Wyoming people today, and appreciate your support. Thank you, Mr. Chairman.
Chairman Newsom.
Thank you, Mr. Chairman. This is a policy decision, and I think we need to be very careful. I mean, we've had a lot of laughs and a lot of jokes, but what makes this different from that $500 bottle of scotch sitting on somebody's shelf in their local liquor store that's not going to turn in 90 days, but they think that it's important to have that on their shelf? And what makes this, a cigar, different from the excise tax paid on liquor, which is paid up front? I think we need to recognize here that we're making a policy decision based on what our belief is on these taxes. So I think that we can equate this to liquor, and we need to think about that. So the next guy with the liquor store down the street that says that $500 bottle of scotch that I haven't been able to sell for 120 days is putting a dent in my cash flow. Well, that's a business decision. And I think we need to think carefully about how we either maintain or don't maintain these taxes. Thank you.
Yeah, thank you, Chairman. I'll just bring it home here after the good representative from the middle of the state certainly helped me out there. You know, as defined in the bill that we have now, that we're now on, you know, it's a wrapped, the cigar is wrapped in whole tobacco leaf. It's handmade or hand rolled. It has no filter, no tobacco tip, or no tobacco mouthpiece. So this is a premium product, and I really respect the point that was just brought up about that bottle of liquor. But you know, these do have a shelf life. It is a concern. I think that as you decide on where you want to go with this, remember that, you know, right now, as it currently sits, our brick and mortars are being poorly affected, and they are paying more. And us as a body, or those that partake in this activity, are paying more than if you were to use your computer to purchase these products. So I'd ask for your favorable consideration, and let's get this out of this process, and certainly would be open to more discussion in a future reading. Thank you.
Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report, to do so with the recommendation that Senate File 42 do pass. All those in favor, please say aye. Aye. All those opposed, say no. No. Senate File 42 is passed. Committee of the whole. The next bill for our consideration is Senate File 57. Reading clerk, would you please read that bill?
Senate File 57, sponsored by Appropriations, State-Held Drainage District Bonds, an act relating to public funds. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 57, State-Held Drainage District Bonds, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. Chairman Nicholas, what's your pleasure?
Thank you, Mr. Speaker. I move when the committee of the whole rise and report it does so with a recommendation that Senate File 57 do pass, and I'll turn the explanation of the bill over to the good representative from Fremont County.
Representative Lloyd.
Thank you, Mr. Chairman. Serving on the Appropriations Committee, we, in hearing the budget for the agency that invests our dollars every year, they come back and they also share with us those investments that they deem are uncollectible. And historically, we have a position that if they're uncollectible, then we take a loss. They provide a way of making sure that those get taken care of. And this year in our budget hearings, they they pointed out that there's this $24,000 uncollectible debt from, and kind of moved on their way, said it's been there for a long time. We kind of caught our attention that evening, and we come back and says, what is that? And it's really an interesting thing, and this will be kind of one of those fun bills that we get to take care of that little piece of grass that's in your sock and poke in your leg. You finally find it and get it pulled out. What happened is in 1935, the North Lincoln, let me find the right name for it. Boom, boom, boom. The Lovell Drainage District up in the northern part of the state had issued some bonds, of which the state had purchased some using some school funds. That bond matured in 1974, but did not pay back any of the debt, and so this $24,000 has remained on the books for about since 1974. And so we saw that and we said we need to take care of that somehow, and so we thought maybe it was a mistake, and so we reached out to that great county treasurer, and they says, well, there was that, and we're showing the same thing. And then there's also another district up here that had issued a similar bond in 1935. This first one is in 1932, my mistake. This next one is in 1935. We're showing that there's a debt there as well. Can we resolve it? And so we checked with the agency that takes care of investments, and they say, we show the second one, but we show that it was satisfied and that there's no outstanding debt. But we feel that we ought to have something there that does that. So this bill goes back in and appropriates $24,000 to the general fund, to the common school account, from which the investment was made back in 1932 to resolve that, where this isn't carried forward on the state treasurer's report year after year after year. And then we clean up the language to ensure the North Bench District, which is still in existence, that indeed that debt that they satisfied has been satisfied, and they can move forward and issue more bonds if they determine so. With that, I'd answer any questions.
Any questions? Question having been called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rise to report, to do so with the recommendation that Senate File 57 do pass. All those in favor, please say aye. Aye. Opposed, say no. The ayes have it. Senate File 57 is passed committee of the whole. The next bill for our consideration is Senate File 118. Reading clerk, would you please read that bill?
Senate File 118, sponsored by Appropriations. Fund balance calculations, federal encumbrances included, an act relating to the administration of government. Mr. Speaker, your committee number 2 appropriations, to whom is referred Senate File 118. Fund balance calculations, federal encumbrances included. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. Chairman Nicholas, what's your pleasure?
Thank you, Mr. Chairman. I move when the committee whole rise and report, it does so with the recommendation that Senate File 118 do pass, and I'll turn the explanation of the bill to the good representative from this town.
Representative Zwanitzer.
Thank you, Mr. Chairman. Members, Senate File 118 has to do with how we handle funds that we get from the federal government. So right now, what we do is we have an agreement with the federal government to build something, and we go out and build it, knowing that we will be refunded that money in the near future. But in the accounting system and the books that we work off of, we have to hold that money in that account till we actually get paid. And so what this bill is attempting to do is to do that exclusion, to say we know the government's going to pay us, because they always have. So I think that just pretty much says it in a nutshell. That way we're able to use those funds. We can put them into savings. We can start another project. We can build items and get the process going. And I think that's the other advantage is we get it out of that 1.2% interest rate that we have it in. And, if we want to keep it in savings, we can put it in one of those higher savings rates. And with that, I would stand for any questions.
Any discussion on the bill? Question having been called, all those in favor of Chairman Nicholas's motion that when the committee of the whole rise to report to do so with the recommendation that Senate File 118 do pass. All those in favor, please say aye. Opposed, say no. Ayes have it. Senate File 118 is passed committee of the whole. The next bill for our consideration is Senate File 122. Would the reading bill clerk please read the bill?
Senate File 122, sponsored by Senator Driscoll. Non-resident workers, vehicle registration extension, an act relating to motor vehicles. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom is referred Senate File 122, non-resident workers, vehicle registration extension, respectfully report, same back to the House with the recommendation that do pass. Ayes, Representatives Banks, Burkhart, Conrad, Heiner, Knapp, Larson, Lawley, Tarver, Western. Representative Burkhart, Chairman.
You've heard the reading of the bill. Chairman Burkhart, what's your pleasure?
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, it do so with a recommendation that Senate File 122 do pass. There are no standing committee amendments, and I turn the explanation over to the good representative from District 27.
Representative Lawley.
Thank you, Mr. Chairman. I bring you Senate File 122, non-resident workers vehicle registration extension, and I ask for your favorable consideration. And I want to submit to you that for all the good little bills we've heard today, this is the very best bill, because this is a bill that originated in Girls State. I don't know if you're familiar with Girls State and Boys State, but it's an amazing program for kids in their junior year of high school to be chosen to participate in which they learn about government by doing government. And this bill arises from a young lady named Jessie Driscoll, who presented this bill, who presented this bill at Girls State and passed it at Girls State. And so her relative, who is the president down the hall, presented this bill to our body to consider, because it is such a great little bill. So being a former Girl Stater myself, I'm honored to present this bill. And it is basically a bill about the registration for vehicles that are temporarily in the state and extending that period of time. So I don't know if you're aware, but under the current law, if you enter the state with a vehicle and are going to work here and you're out of state, it's registered out of state, that you have to get a temporary permit for that vehicle, and you get that permit and pay for it by the month. And you get a decal that represents that you have been permitted to do that. The statute currently allows a 120-day period. And after that 120-day period, you will have to get a permanent registration in this state. So this bill simply extends that 120 days to 180 days. And that is what the bill is about. We did hear from a number of industries that support the bill, and the department that handles our transportation talked to us and said that this is a temporary decal. By passing this bill, we don't waste any money. It doesn't cost any more money in order to extend that time. And with that, I'll stand for questions.
Any questions? Chairman Washit.
Thank you, Mr. Chairman. Just a quick question. Was there any testimony about the level of compliance with the existing law? How many people really get these permits?
Representative Wally.
Thank you, Mr. Chairman. I don't recall, we did have a discussion about maybe some confusion on some people's parts about when they have to get the decal, which is immediately, and how long it lasts, and possibly even some ways that could be adjusted at some point and looked at, I think there probably is uneven compliance, but we didn't really talk much about that.
Representative Zwanenzer.
Thank you, Mr. Chairman. And the fact that we're increasing the time period double, was there any extra talk about increasing the fee from $50 up to $100.
Well, the way the program works, again, I appreciate the question. Mr. Chairman, thank you.
Thank you, Representative Lawley.
The way the program works is that the fee is paid per month. So it doesn't affect the fee. We just stretched it out 60 days, so 2 more months, and the fee is paid during those months. So there's no revenue. It's just a matter of how long they can continue to pay that fee and have a temporary permit versus getting a permanent permit licensing.
Any other discussion on the bill? Question having been called, all those in favor of Chairman Burkhart's motion that when the committee of the whole rises to report it, do so with the recommendation that Senate File 122 do pass. All those in favor, please say aye. Opposed, say no. Senate File 122 is passed committee of the whole. Majority Floor Leader.
Thank you, Mr. Chairman. I move the committee of the whole rise and report.
You have heard the motion. All those in favor, please say aye. Opposed? Motion carries.
The reading clerk will read the committee of the whole report.
Mr. Speaker, your committee of the whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 5, do pass. Senate File 6, do pass amended. Beg leave to rise and sit again at 2 o'clock. Convening, Senate File 14, do pass. Senate File 15, do pass. Senate File 17, do pass. Senate File 24, do pass. Senate File 26, do pass. Senate File 33, do pass. Senate File 36, do pass. Senate File 39 failed to pass committee of the whole and was indefinitely postponed. Senate File 42, do pass amended. Senate File 57, do pass. Senate File 118, do pass. Senate File 122, do pass. Representative Haroldson, Chairman.
Chairman Haroldson.
I move the adoption of the committee of the whole report.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion carries. Congratulations, Representative Haroldson. The House will please come to order. Good job, Representative Haroldson. Messages from the Senate.
Message number 8. Mr. Speaker, the Senate has completed consideration of the Budget Bill, Senate File 1. In accordance with Joint Rule 14-1G, the bill has been referred directly to a conference committee of 5 members to meet with the like committee from the House to report recommended amendments for final consideration by both houses with respect to both budget bills, House Bill 1 and Senate File 1, and the amendments thereto. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 294. I'll get to that in just a moment. Message 277. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 10, County Officers, Bond Amounts, and Surety Requirement. Ayes 29, noes 2. Message 278. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 12, Presumptive Child Support Amounts, Updated Tables. Ayes 24, noes 7. Message 280. Mr. Speaker, The bill listed below passed the Senate on third reading by the vote indicated. House Bill 28, Community College Capital Construction. Ayes 25, noes 6. Message 281, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 29, Community College Funding, Distance Education Credit Hours. Ayes 30, noes 1. Message 283, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 39, Verifying the Veteran Designation on a Wyoming Driver's License. Ayes 31. Message 285, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 45, Peace Officer Retirement and Rehiring. Ayes 26, noes 5. Message 292, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 50, Solid Waste Cease and Transfer Program Funding. Ayes 31. Message 288, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 97, Chancery Court Jurisdiction Amendments. Ayes 31. Message 289, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 111, Endangering Children, Fentanyl. Ayes 28, noes 3. Message 290, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 112, Theft Penalty for Fifth or Subsequent Offense. Ayes 28, noes 3. Message 291, Mr. Speaker, the bill listed below failed to pass the Senate third reading by the vote indicated. House Bill 51, Legislator Constituent Service Allowance. Ayes 5, noes 26. Sincerely, Ellen Thompson, Senate Chief Clerk.
Reports from standing committees.
Senate File 18, sponsored by Transportation. Benefits for spouses of law enforcement members, an act relating to the administration of government. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom is referred Senate File 18, Benefits for Spouses of Law Enforcement Members, respectfully report same back to the House with the recommendation that do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Stivar, Wiley. Representative Brown, Chairman. Senate File 19, sponsored by Transportation. Highway Safety, Child Restraints, an act relating to motor vehicles. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred Senate File 19, Highway Safety, Child Restraints, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Stivar, Wiley. Noes, Representative Smith. Representative Brown, Chairman. Senate File 20, Transportation, sponsored by Transportation. Driver's license and ID card photo quality, an act relating to driver's licenses and identification cards. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred Senate File 20, engrossed, driver's license and ID card photo quality, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Wiley. Noes, Representative Smith, Stivar. Representative Brown, Chairman. Senate File 41, sponsored by Revenue. Skill-based amusement games, authorized locations, an act relating to gaming. Mr. Speaker, your committee number 3, Revenue, to whom was referred Senate File 41, engrossed. Skill-based amusement games, authorized locations, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrop, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman. Senate File 59, sponsored by Travel. State Parks Account, Agency Expenditure Authority, an act relating to state lands. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred Senate File 59, State Parks Account, Agency Expenditure Authority, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Angelos, Burkhart, Byron, Larson, Newsom, Storer, Western, Winter. Noes, Representative Singh. Representative Newsom, Chairman. Senate File 63, sponsored by Revenue. Tax Administration Revisions, an act relating to taxation and revenue. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 63 engrossed. Tax Administration Revisions. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman. Senate File 68, sponsored by Select Water. Prescriptive easement for water conveyances, an act relating to prescriptive easements. Mr. Speaker, your committee number 5, Agriculture, State, and Public Lands and Water Resources, to whom is referred Senate File 68 engrossed, prescriptive easement for water conveyances, respectfully report, same back to the House with the recommendation to do pass with the following amendments. Ayes, Representatives Alaman, Allred, Banks, Conrad, Davis, Eklund, Slagle, Winter. Excused, Representative Crago. Representative Eklund, Chairman. Senate File 74, sponsored by Agriculture. Slow-moving vehicles, amendments, an act relating to motor vehicles. Mr. Speaker, your committee number 5, Agriculture, State, and Public Lands and Water Resources, to whom is referred Senate File 74 engrossed. Slow-moving vehicles amendments, respectful report, same back to the House with the recommendation that do pass. Ayes, Representatives Alaman, Allred, Banks, Conrad, Davis, Slagle. Noes, Representative Eklund, Winter. Excused, Representative Crago. Representative Eklund, Chairman. Senate File 88, sponsored by Travel. Hunting licenses, weighted bonus point system, an act relating to game and fish. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred Senate File 88. Hunting licenses, weighted bonus point system, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Angelos, Burkhart, Byron, Larson, Newsom, Storer. Noes, Representative Singh, Western, Winter. Representative Newsom, Chairman.
That's it. Any re-referrals? Does that clear the deck? So just a note, as you guys have probably heard, I don't believe the Senate is meeting tomorrow. Despite the mutiny that's been kind of moving around here. We are going to meet in the morning, but we will be done by noon. Any committee that has a person that's a personal bill of somebody in the Senate probably is not going to hear that because the Senate's gone. But any committee tomorrow that has committee bills will just continue to hear committee bills because they've come out of the interim. And so we'll run till noon. If the noon committees want to meet, they can meet. If they don't want to meet, they don't have to, and then we'll go home. So that's kind of the nature of it. We got quite a few bills on second reading. I don't know how many will get amended, maybe none, and then we'll have some on committee of the whole. So that's the route I'm taking. So Mr. Majority Floor Leader.
Mr. Speaker, I move the House adjourn until 10 a.m. tomorrow, Friday, the 10th day of February 2023.
Committee announcements, and just a reminder to the committee chairs, make sure you mention to your committee secretaries your plans for tomorrow so they know whether you're meeting or not meeting and all of that. So Chairman Northrup.
Thank you, Mr. Speaker. Your committee number 4 will still meet tomorrow morning at 7 o'clock for education of education in our usual place.
Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations will meet on adjournment. We'll have Senate File 158 and also a re-referral of Senate File 51. We will also meet tomorrow on noon recess, here Senate File 71.
Chairman Washit.
Thank you, Mr. Speaker. Your committee number 1, Judiciary, will meet 8 a.m. tomorrow morning in our normal room. We'll hear 3 bills. Senate File 34 will be continued from our previous discussion. Senate File 31 and Senate File 25.
Chairman Olson.
Thank you, Mr. Speaker. Your committee number 7, House Corporations, Elections, and Political Subdivisions, will not meet tomorrow upon noon recess, as was previously noticed. We will meet on Monday at noon recess to hear the bills
that were noticed erroneously for today, Senate File 40 and Senate File 43.
Chairman Zwanitzer.
Thank you, Mr. Speaker. Committee number 10, Labor, Health, and Social Services will meet tomorrow at 8 a.m. We will definitely hear Senate File 11, Cancer Early Detection Amendments, and may get to other Senate files, or may not.
Any other committee announcements? Chairman Burkhardt.
Thank you, Mr. Speaker. Your committee number 9 will not meet tomorrow. We will meet on Monday at 8 a.m. to consider Senate File 173, Senate File 116, and Senate File 139.
Anybody else? You've heard the majority floor leader's motion. All those in favor say aye. All those opposed? Motion carries. The House is adjourned until 10 a.m. February 10th, 2023.